Chat with you a little bit about the some of the new developments we've had in the DMV on non-compete laws. Hopefully everyone can see my screen okay. So Virginia is having the sort of biggest change in the non-compete laws. Virginia, as you may remember, in prior presentations, for those of you who have known me for a number of years, and I see a number of our longtime clients on, we used to refer to Virginia as the Wild West of employment law in the DMV. Really, not so much anymore, and we've seen a lot of different changes in Virginia employment law over the last few years. One of the big ones that we saw back in July of 2020 was Virginia implementing a fairly significant restriction to its non-compete law. So the new law that we're talking about today will go into effect in 2025, but I want to provide the background for the law that went into effect in July of 2020 because this is a modification of that law. So the original Virginia non-compete law that went into effect in July of 2020 provided that employers may not enter into, enforce, or threaten to enforce covenants not to compete with any low wage worker. So it's not just enforcing, threatening to enforce, entering into a loan is a problem under this statute. And a covenant not to compete under the Virginia law is fairly broadly defined. I have the definition here on the slide. It's anything that restrains, prohibits, or otherwise restricts an individual's ability following termination of the individual's employment to compete with the former employer. And it's important to note that the statute specifically states in the language later on below this quoted language that it includes restrictions that would prohibit an employee from providing services to a customer or client of the former employer as long as the employee didn't initiate that contact or solicit that contact. So gone are the provisions that we've talked about before. Well, for those employers that are the employees that cannot be subject to it, the provisions that we sometimes see of you can't go work directly from one of our clients or customers, or you cannot go work for another company and also service our client or customer. If someone who is considered in this low wage category goes to work for another client or customer directly, perhaps you are outsourcing some type of resource for them and they brought one of your employees in internally, you can't prohibit that under the non-compete law. Additionally, as long as the individual is not soliciting those customers and clients for a new employer, you can't prohibit them simply from providing services to someone who is formerly your customer or client. Now, the Virginia law does not really get into the lines as to when it is and is not acceptable to have a non-solicit. However, it does acknowledge to some extent that non-solicitation provisions, as far as non-soliciting employees or clients, could potentially be enforceable even with this low wage group, as long as it's not a situation where essentially you're preventing someone from going to work for another employer. The statute does also make it absolutely clear that they are not intending to prohibit non-disclosure provisions. And additionally, the focus here is on post-employment. You'll hear me touch on when we get to DC talking about moonlighting provisions. Here, Virginia's law is focusing on non-competes post-employment. So anything that would restrict an employee from going to work for a competitor after they leave your employment. So looking at what constitutes a low wage worker, low wage workers in Virginia under the definition is someone who is earning less than the average weekly wage in the Commonwealth. And this is a bit of a moving target because this is determined annually. So for 2025, the numbers that we got, and typically it's somewhere between November and December of the year before, Virginia will announce what they're considering the average weekly wage for the coming year. This year, it's about 1,400, a little over 1,400 a week, or 76,000 a year. So when we're talking about low wage workers, for many, many employers, 7,600 is definitely not necessarily what they would think of as a low wage worker, but that is the threshold that Virginia is using. So the new law that just is going into effect on July 1st of 2025 will expand the categories of who cannot be subject to these non-competes. So we're retaining the existing restriction on having non-competes with low-wage workers, but they are adding in and expanding the restriction to also prohibit non-competes for any employee who's considered non-exempt under the FLSA, regardless of how much they make. So now employers are needing to check two things. First of all, anybody who's non-exempt, even if they're making 150,000 $200,000 a year, if they cannot be qualifying as non-exempt under the FLSA, you cannot subject them in Virginia to what would constitute a covenant not to compete. And additionally, if you have folks who are being paid under that $76,000 threshold per year, even if they are exempt, they may fall under one of the exemptions and be paid 70,000 a year and qualify as exempt under the FLSA. They too cannot be subject to that restriction. The way that the new law is going to work, it's not going to apply retroactively. So it will not impact existing non-competes with non-exempt workers that were entered into before July 1st, 2025. So we have seen some employers who are rolling out non-competes now with those folks who are no longer going to be able to sign non-competes as of July 1st, 2025 to get those grandfathered in. That's one potential consideration. But also it's not going to wipe out any agreements you have that predate this new provision going into effect on July 1st, but it is something to be mindful of going forward. And one reason we want to be particularly mindful of it is that the restrictions apply and provide both a private cause of action for individual employees to sue an employer who attempts to enforce an unlawful non-compete against them. And that includes a right of the employee to recover their attorney's fees and costs incurred in that lawsuit. So our sort of standard private right of action, but it also provides for civil penalties of up to $10,000 for each violation. And that's why I was emphasizing when we started that the law prohibits even just entering into these types of non-compete agreements. So in many jurisdictions, the way that their non-compete laws are structured, really sort of the onus and the problem arises for the employer when they actually try to enforce an unlawful non-compete. So there's really not a lot in the way of penalties just for having someone sign an unlawful non-compete. It's if the employer attempts to enforce. But here, the way that the Virginia law is structured is a little bit unique in that the Commonwealth can impose these civil penalties simply by virtue of the fact that the employer has the employee sign an agreement that would be unlawful, even if the employer does not intend to or has never attempted to enforce that unlawful non-compete. So important to go back and take a look first from the perspective of compliance with the original 2020 law to make sure that we don't have any agreements now with folks who are considered low-wage workers that we had asked them to sign. We need to make sure that those are nullified. And then going forward, making sure we're not asking any low-wage workers or non-exempt workers in the Commonwealth to sign non-competes because we are potentially seeing civil penalties for those. Employers are also required to post notices of the non-compete law, the same place you'd post your standard federal and state notices on a bulletin board, on your intranet. Civil penalties can be applied for just failing to post the notices. So making sure that you're getting those updated posters from your poster companies that include the updated Virginia notice will be important as of July 1st. So taking us through, that's the biggest non-compete development in the area, but did want to flag another change that we're seeing in Maryland. Maryland non-compete law dates back a little bit further than Virginia, prohibits employers from having non-competes with employees who are earning less than 150% of the state minimum wage, which is currently $15 an hour. What I wanted to flag in the context of this topic with Maryland is there are two important changes that have come over the last year and a half or so, and one that is going into effect on July 1st. So actually jumping forward a little bit on my slide, as of June 1st, 2024, licensed vets and vet techs cannot be subject to non-competes in Maryland. So being careful that we do not have any, if you have any vets or licensed vet techs, no non-competes for them, and that wipes out any non-competes that were in existence as of June 1st, 2024. So there's no grandfathered in for the vet and vet tech non-competes. The big change that we're seeing coming this summer is any licensed healthcare provider. So that's any healthcare provider in Maryland that's licensed under the Health and Occupation article, which can include registered nurses, physicians, physical therapists. So again, any of these licensed healthcare providers who are providing direct patient care and earning $300,000 or less in total compensation annually cannot be subject to non-competes. And that's fairly significant because it is going to be capturing a lot of these healthcare providers who are often or traditionally have been subject to these non-competes. And again, reminding you that it's not just the doctors, it's not just the high-level medical professionals, it's anyone who's licensed under that health and occupational article. And for those who you can have a non-compete, so those licensed healthcare providers, as of July 1st, there will also be limitations on the types of non-competes that you can ask them to sign. So where the licensed healthcare provider makes more than $350,000, so they wouldn't be subject to that straight prohibition against non-competes. The non-compete can't be for a period of greater than 1 year from the individual's last day of employment. So no more 18 months, no more 2-year non-competes. 1 year is going to be the max for these healthcare provider non-competes. And the geographic scope can't be greater than 10 miles from the primary place of employment. So again, those are significant changes to those individual agreements. And the big difference between the vets and the healthcare provider provision is that the healthcare provider provision is not going to knock out those agreements that were signed before July 1st. So if you'd entered into a non-compete with someone making less than $350,000 who's a healthcare provider before July 1st, that is still going to be effective. If you have a longer period or a greater scope with a healthcare provider, that is not going to get knocked out by the law, just because the law specifically only applies to agreements that are entered into on or after that July 1st, 2025 date. So we're not knocking out old agreements. It's going to be agreements prospectively and impact the new agreements. But, do be careful if you're amending or renegotiating any of those contracts that might contain these restrictive covenants. You're going to be reopening those, and it'd be considered a new agreement. So you want to be extremely careful if you have agreements that might be grandfathered in to leave them alone if you're hoping to continue to enforce them. And one final note on the healthcare provider, also part of the provisions applicable to those who are making greater than $350,000. Even if you have someone who can be subject and is subject to a non-compete under this provision, at the request of a patient, you still have to provide the patient with the location and information of where the employee is now going to be practicing. So you can't avoid providing a patient who wants to follow their doctor, who has gone to somewhere else and is subject to this non-compete restriction. You can't avoid providing that information to the individual. So looking the other DMV areas, just, to give you the full picture of what we're talking about, over the last year or so, we talked a lot about the Federal Trade Commission non-compete ban. Those are the regulations that came out from the FTC about a year and a half ago. Those are on appeal. You may remember from some of our prior presentations, we've covered that there was a decision out of the district court in Texas back at August of last year, right before, on the eve of those nationwide non-compete laws going into effect. The federal district court in Texas knocked that out. These are really unlikely to ever go into effect because there was an appeal by the FTC under the Biden administration to the Fifth Circuit to request a reconsideration of that nationwide injunction that was knocking out these non-compete rules. The FTC on March 7th of this year requested and was granted a 120-day stay of its appeal, which kind of suggests the likelihood that they're going to change course. And as the administration has done on a few of these different Biden-era rules, decide that they're not actually going to continue to fight for the enforcement of the rules. So we're probably not going to see the FTC non-compete rules become an issue. And it is also pretty unlikely that any of the other agencies, including the NLRB, are going to take up any of these non-compete issues while the Trump administration is in control. As far as District of Columbia, we have covered these on prior webinars. They went into effect on October 1st, 2022. So they're a little bit older than some of these other developments we've been talking about today. But I did want to just flag one thing that keeps tripping folks up because of how unique it is compared to some of the other non-compete laws. As I mentioned, for Virginia, really the focus, in the way that the language is structured, is on what happens to employees once they leave the employer's employ, and are we restricting where they can go on their next step in their next employment. The DC law is somewhat unique across the country in that it specifically includes anti-moonlighting clauses in its non-compete restrictions. So it bans these non-competes for employees who are earning below the annually adjusted threshold, which is now approximately 158,000 for non-medical specialists, and then $263,000 for medical specialists. Um, so the restriction on prohibiting employees from competing also includes a restriction on allowing employees to have side jobs or side employment unless they fit into that restriction, or that side employment fits into a very specific exception within the law. So just flagging that for employers. Most folks are focused on sort of what happens as the next chapter. Are we restricting, and what are we allowed to restrict when an employee leaves? But being mindful of the fact that if you are in DC and you have restrictions on what employees can do while they are currently employed in DC, whether that's in your handbook or in a contract, really making sure that that falls into one of the exceptions that allows for these anti-moonlighting clauses, because otherwise it's potentially problematic under the DC law. And then also flagging that when we're talking about these thresholds in DC, DC is very stringent in that the salary threshold has to be met both at the time the agreement is signed and at the time of enforcement. So if you have someone who, happened to have signed an agreement that maybe we shouldn't have had them sign back when they were making 120,000, but now they're making 160,000, that is going to impact the enforceability, because it has to be someone who it was lawful at the time they signed and the time we're looking to enforce. So again, keeping that in mind as we're potentially placing restrictions on DC employees. So that is my update. I'm going to see if I can close out my slides and check if there's any questions. And so since it doesn't look like there's any questions for my part of the presentation, we were going to open it up, just since this is our annual spring cleaning webinar. If you have any questions that you'd like to have answered just on anything that's on your mind as you go into the spring and summer on the employment issues, please feel free to type them in now, or you know where to find all of us, and we're happy to answer them offline as well.